The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 914, coming to you on Monday the 17th of September 2018. On this program, I will speak to you on the topic Procedural Safeguards in Death Penalty Cases. And before I get into the topic, a brief preliminary. As usual, condolences go out to all families which have suffered recent bereavements. I wish to get right into the program because the contents are very long, and if perchance I do not cover all of the points I wish to speak about, I will continue next week, Monday, DV. So here goes. Procedural safeguards in death penalty cases. I wish to highlight the fact that whatever may the case in other countries, here in St. Vincent and the Grenadines, it is extremely unlikely that the wrong person could end up on the gallows in this country. Extremely unlikely. Every now and then we hear in the United States of America that somebody who had been convicted 15, 20, 30 years ago and had served a long sentence was exonerated by new DNA evidence because they had been wrongly convicted. Very, very difficult for that to happen here in St. Vincent and the Grenadines. And if you listen to me carefully, when I'm finished with this topic, you too would be satisfied that the chances of an innocent person being executed here following a trial for murder are so slim as to be practically non-existent. And when I go through the points, you will see why. I've identified 12 procedural safeguards which operate in the criminal justice system in St. Vincent and the Grenadines where the death penalty is concerned. Firstly, even before a person is placed on trial before judge and jury, there has to be a preliminary inquiry whereby a professional magistrate must certify that there is enough prima facie evidence to place the person on trial for the offense of murder. I will not deal with the other death penalty offenses because they are of rare occurrence: treason, misprision of treason, and so on. So the ball starts rolling here in St. Vincent and the Grenadines whenever somebody is arrested on suspicion of having committed murder. The ball starts rolling before an inquiring magistrate. At the PI, or preliminary inquiry, the prosecution has to put forward enough credible evidence tending to link the accused person with the offense of murder with which that accused person has been charged. At the stage of the PI, the defense hasn't got to say a word. They don't have to put forward any evidence at all. I know these days they are moving towards what is called paper committals, where enough evidence has to be laid in documents But for the time being, we still have PIs, preliminary inquiry. So that is the first safeguard. If the prosecuting authorities do not have enough evidence to satisfy the magistrate that that particular individual ought to stand trial for that particular murder, then that is the end of that. Of course, the prosecution can come again with a fresh PI, but they have to get past that first hurdle. That is the first safeguard before anybody could be placed on trial for murder. The second safeguard is that in St. Vincent and the Grenadines, no one can be tried for murder without having a lawyer to defend him or her. There's no such thing as a person standing trial for murder here alone, defending himself or herself. No way. If the person cannot afford a lawyer of his own or her own, then the state, the Crown, has to provide to that person the services of a lawyer, free of charge. In some countries, it is possible for somebody to be placed on trial without having a lawyer to defend them, although most civilized countries have what are called public defenders. But here in St. Vincent and Grenadines, the second safeguard is that nobody can stand trial for murder without having a lawyer. Before I leave that second point, let me make a comment. Over the years, the point has been raised that persons facing preliminary inquiries should also be given free legal representation. It is a notion which I support, but the state may say they don't have enough resources because the lawyers the state engages have to be paid. But the time may well come when even at the PI stage, accused persons are given free legal representation by the state. But for the time being, persons who can't afford a lawyer at the PI stage have to do without one. But if they are sent on for a murder trial, before judge and jury, they must have a lawyer. That is safeguard number 2. Safeguard numbers 3, 4, 5, 6, 7, 8 are matters having to do with the trial itself. And I have identified safeguard number 3 as the need for a jury trial. In St. Vincent and the Grenadines, no one can be tried for murder unless it is before a jury. And in our system, jurors are randomly selected. Literally, the names are pulled from a hat. That is, the Jury Act sets out a number of qualifications that people need and the disabilities for jury service. And there is a list of names, each name having a number. And you know the way that they pull balls from games of chance with a number. Well, at the trial for murder, the selection of the jury, after the jurors have been summoned and all the names of the available jurors are placed in a container, the registrar or the registrar's clerk reaches into the container, pulls out a number, and looks to see whose name is on the list as answering that number, then that person is called from all the waiting jurors in the courthouse, in the courtroom, and the person comes up and takes his or her seat on the jury panel. So that unless a full panel of jurors are selected at random, a jury trial for murder cannot begin. A trial for murder cannot get off the ground. You may say, well, what is to prevent a member of the jury from being biased or from having one defect or another? But at the very least, the system guarantees to every person that 12 members of society sit throughout the trial to judge whether you are guilty or not guilty. Now, the jury is a peculiarly British institution. It has stood the test of time. The notion of jury service is something accepted in practically all parts of the civilized world where there are jury trials. In some countries, you don't have trial by jury, you have trial by judges. And that is how their systems work, where a panel of 3 or 5 judges listen throughout the case, and at the end of the case, that panel decides if the accused person is guilty or innocent. So some countries don't have the jury system. We in the Commonwealth Caribbean have the jury system, as in practically all parts of the former Commonwealth. They were former British Commonwealth, now the Commonwealth of Nations. And that guarantees that you are tried by a jury. The quaint phrase is a jury of your peers. Well, that may have been an apt description in times gone by, but I don't think it could honestly be said that juries are of the peers of accused persons. But our jurors, our jury panels are 12 persons on murder cases, 12. You can start with 12, and if one gets ill, you reduce to 11. If 2 get ill, you reduce to 10. But the case cannot go forward for decision with fewer than 10 members of the panel. If during the trial 1 or 2 are disqualified, that's it. And the jurors are required to bring in a unanimous verdict, or after a certain amount of time, the judge will accept a majority verdict, but not less than 10. So that for anybody to end up on the gallows in St. Vincent and the Grenadines, that person would have had to been tried before a 12-person jury and found guilty by that jury, or by at least a majority of them, a majority of at least 10 out of the 12. Which means one can safely say that a person accused of murder cannot be hanged for the offense if fewer than 10 citizens hearing the whole case decide from the evidence they have heard during that trial that that individual is guilty. Now, you may say that in some cases the individual might have been unlucky and the jury might have been this and that and so on, but in my experience, jurors in this country are more likely to bring a person not guilty if they entertain any doubt than to bring the person guilty. And the jury system has to be respected, because while jurors might not be persons who have gone to university and got degrees, they are persons of integrity, persons of solid common sense, and they would listen faithfully to the case and make their decision in accordance with the evidence they have heard and with the directions they would have received from the trial judge. I move on now to safeguard number 4. There are other things I could say about the jury, but I want to cover the material. As I said, if I don't cover the whole topic in a satisfactory manner, I will return and finish up next week, DB. So, safeguard number 4. It's the presumption of innocence. That is written into our Constitution. Our Constitution says that any person charged with a criminal offense before any court of law must be presumed to be innocent unless he has been found guilty or unless he or she has pleaded guilty. That presumption of innocence distinguishes us and other countries with the common law tradition from some civil law countries where there's a presumption of guilt. And when you go on trial, you have to prove your innocence in those countries, not so in St. Vincent and Grenadines. If you attend any criminal assizes and the judge comes and you listen to the judge's summing up, the judge will say to the jury, the accused person hasn't got to prove one thing, unless in the rare cases where the burden of proof shifts on the accused. As for example, if the accused depends on the defense of alibi, if he is saying, look, I was somewhere else at the time when the offense was alleged to have taken place. Well, if he sets up a defense of alibi, he has to prove it. Otherwise, the accused person hasn't got to say a word in his defense. It's the prosecution. The burden of proof rests on the prosecution to satisfy the jury that the accused person was guilty of the offense charged. And it is not for the accused person to establish his innocence. And that constitutional safeguard applies to all offenses, not just death penalty cases. The 5th procedural safeguards, well, I have grouped into one item the rules of evidence. Now, the victims of crime are usually amazed, astonished, and enraged when they, at their own, the trial in which they are the victims, when they hear defense counsel, that is the lawyers who appear on behalf of the accused persons, raise objection to certain bits of evidence being put in, and the judge upholding those objections. For example, if somebody has been placed on trial for killing a close relative of yours, and you go to the courthouse every day of the trial, following it, you get mad when the prosecution attempt to place before the jury a certain bit of evidence, defense counsel objects, and the judge upholds the objection and says the defense counsel is right, you cannot place that evidence before the jury. In the British Commonwealth system, common law system, the rules of evidence are generally referred to as exclusionary. That is, they tend to exclude, to keep away from the jury certain things. And the prosecution, in placing their evidence before the jury, have to follow certain strict rules. For example, there are some rules prohibiting certain kinds of police evidence from being placed before the jury, depending on how that evidence was obtained. So the police have to be very careful when they investigate all cases, particularly murder cases, to make sure that the evidence they collect have been collected in accordance with the rules. Because if they make wrong steps and do wrong things and don't follow proper procedure, the accused person could get off of the charge. So that the criminal justice system in this country is very careful to make sure that only evidence which has been brought before the court pursuant to certain procedures is allowed to stand against the accused person. So I have labeled the rules of evidence as one procedural safeguard. I go now to number 6, and these are just my enumeration. Number 6, the rules against confession statements. Well, confession statements form a species of evidence, but they have their own rules. The prosecution in criminal cases, particularly murder cases, are not allowed to tender in evidence an alleged confession unless the prosecution satisfies the judge that the confession has been obtained in a voluntary manner. In other words, you can't beat a witness or beat an accused person and extract an evidence through brutality and expect that evidence, if the judge believes the accused person when he says, look, I didn't give that statement voluntarily, I was beaten, if the judge believes that, that confession statement cannot stand. Because the judge will say, look, the confession has to be voluntary, the person has to volunteer it, the person has to make the confession out of his own free will. If the person shows that he was promised lenient treatment in exchange for making a confession, again, the judge will say that confession statement cannot be placed before the jury because it was obtained by means of jurors' influence. If the person was threatened, again, a confession statement taken as a result of threats would not be allowed to stand as part of the evidence against the accused person. The next procedural safeguard, I would call it number 7. I label it as the summing up. Now, in our system, where we have judge and jury at murder cases and other indictable cases before the High Court, the function of the jury is different from that of the judge. And if you listen to a judge's summing up, the judge will tell the jury, you have to decide the facts in this matter. I, the judge, will decide the law. Therefore, the role of the judge in a criminal trial is to guide the proceedings in accordance with the rules of procedure and to sum up the evidence for the benefit of the jury, but it will be for the jury to make the decision whether somebody is innocent or guilty. The summing up in a criminal trial, and particularly in a murder case, is very important. And when you hear a person file appeals against conviction, they normally quarrel with aspects of the judge's summing up. And if the judge doesn't follow certain rules relating to the summing up of cases, the Court of Appeal hearing the appeal would allow the appeal and say, no, the judge went wrong. Because there are certain things which the judge is expected to explain to the jury, and certain ways in which the judge has to conduct himself or herself during the trial. If, for example, the judge has been particularly active in the case, intervening all the time and practically want to take over the prosecution of the case, and that is shown by the transcript of the trial, a Court of Appeal listening to an appeal on that would say, no, the judge descended into the arena and the judge should have kept out of that. The judge was not fair, didn't do the proper things. And that is one aspect of the criminal procedure which is very important. Well, our time has been exhausted and I will leave the other points, that is 8, 9, 10, 11, and 12, for next week, Monday, DV. I hope you who have looked at this program will have the opportunity to look at the continuation next week, because there are other safeguards I will bring to your attention, 12 in all, to show you that when somebody eventually ends up on the gallows in St. Vincent and the Grenadines as a result of having been convicted of the offense of murder, that person would, in practically all cases, have been properly convicted and properly sentenced to death, because the law bends over backward to avoid innocent persons being penalized in our criminal justice system in St. Vincent and Grenadines. There is an old maxim that it is better for 100 guilty persons to go free than for one innocent person to be convicted. And the criminal justice system in this country is so strict that the chances of wrong convictions, and even more extreme, the chances of wrong executions in St. Vincent and Grenadines are so slim as to be practically non-existent. But I will continue with the topic next week, Monday, DV. Let us thank the Lord for having spared us from Hurricane Isaac. Let us pray that He would have mercy on those countries which suffered, whether from high winds, high seas, or high levels of rainfall. Let us reach out to the persons in the United States of America who are afflicted by Hurricane, now Tropical Storm Florence. And above all, let us hope that the good Lord will bless us all. Until next week, Monday, DV. Ladies and gentlemen, brothers and sisters, boys and girls, do have a pleasant week.
The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.